Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, do you guys ever get the impression that the court system is just screwing with you? That even though there are case after case after case all ready for important landmark decisions, it just seems as though those decisions never come. Does it ever seem like sometimes the Supreme Court actually remands a bunch of cases back to the lower court and says, hey, why don't you do it over and use the correct legal analysis this time around, and then they just seem to disappear, never to be heard from again? Well, this is one of those cases we're going to be talking about today. It started many, many years ago, and it continues today, and finally, the plaintiffs have just had enough. And they've said, you know what, enough is enough. Let's just take this thing directly to the Supreme Court, and it deals with assault weapon bans. So this case has the potential to be really, really big. So today, let's break it all down for you and let's talk about this is how you force assault weapon bans before the Supreme Court. Okay, so the case we're talking about today is the case of Bianchi v. Brown. You go, whoa, wait a second, Bianchi v. Brown. Yeah, that's right. It used to be called Bianchi v. Frosh, but of course, in the meantime, they've changed attorney generals in the state of Maryland. This is a challenge to Maryland's assault weapon ban. Now, just to give you an idea of how these cases can be aged out by courts that support civilian disarmament, let us remember that Duncan v. Bonta and Miller v. Bonta were both originally called Duncan v. Becerra and Miller v. Becerra. And this case also had a previous name to it, and due to the age of it, we now have a new caption on the top of this case. Now, for those of you who've been trying to follow this case amongst the other three that were GVR'd back down from the United States Supreme Court 2 summers ago, after Bruin, this case was heard by a 3-judge panel finally, and then months and months and months after the 3-judge panel heard it, for whatever reason, the court issued an order for a full en banc review without the panel ever issuing a ruling. Clearly, it indicated that probably the full en banc panel was not happy with the panel ruling that was about to be authored and decided to circumvent the process. This has led to our good friends at the Second Amendment Foundation, so kudos to everybody at the Second Amendment Foundation who's spearheading this litigation to finally say, you know what, let's just dispense with all of the shenanigans, all the gamesmanship, all the delay tactics, and let's get this thing directly to the United States Supreme Court. So they have filed a petition for certiorari. But here's the thing, and I want you all to understand this so we don't get our hopes up too high. Being granted a petition of certiorari by the United States Supreme Court is already kind of like finding a unicorn that poops ice cream, okay? What we're asking for here is a petition under Rule 11, which is a petition for review before we've even received ruling from the lower court. It's Supreme Court Rule 11, and that rule reads, a petition for a writ of certiorari to review a case pending in a United States Court of Appeals before judgment is entered in that court will be granted only upon a showing that the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in this court. Wow. That seems like a very lofty burden, and it is indeed. But when you consider the gamesmanship that has gone on in this case and many other cases, we can go out to the Ninth Circuit and see example after example after example of that. And then you take a look at what the plaintiffs have pled here. This is a pretty persuasive petition. I'm going to share with you the pleadings because I think it's really well done, and I think it really outlines exactly what's been going on here. Now, let us remember that Bruin was decided in the summer of 2022, and it very clearly put forth the true standard by which we would analyze the constitutionality of gun control legislation moving forward. It also absolutely, positively reaffirmed the Heller decision, but apparently many courts have not gotten the memo, as the plaintiffs put it. Following Bruin, the unconstitutionality of semi-automatic rifle bans is clearer than ever. For in Bruin, the conceded fact that handguns are, quote, in common use today for lawful purposes was sufficient to establish constitutional protection of the type of arm at issue in that case. And Bruin further explained that colonial bans on dangerous and unusual weapons could not justify laws restricting the use of weapons that are unquestionably in common use today. To the extent any doubt about the constitutionality of bans on common arms was left by Heller, Bruen eliminated that. And yet today, a year and a half after Bruen, history is repeating itself as the Federal Court of Appeals are failing to heed the clear teaching of this court's precedents. And then check out some of these examples that plaintiffs point out. The Seventh Circuit somehow concluded that its decision in Friedman is basically compatible with Bruen and embraced the Fourth Circuit's pre-Bruen most useful in military service test to refuse to enjoin Illinois' ban on modern semi-automatic rifles and other arms. An en banc panel of the Ninth Circuit reached out to stay an injunction against a California law restricting the capacity of ammunition magazines. And a panel of that court is holding a case challenging California's ban on modern semi-automatic rifles and other firearms pending the outcome of Duncan. If history is any guide, the en banc panel is unlikely to rule in favor of the Second Amendment. But then the court points out the shenanigans going on in this case. The actions of the Fourth Circuit below in this case are the most brazen yet. The Fourth Circuit initially affirmed the dismissal of petitioner's claims by applying that court's precedent in Colby. Petitioner sought review in this court, and this court granted review, vacated the decision below, and remanded for further consideration in light of Bruen. Now remember, that GVR took place in the summer of 2022. Consistent with the remand order, a panel of the Fourth Circuit heard arguments in December of 2022. In January of 2024, however, the court issued not an opinion, but rather an order granting a rehearing en banc despite no party requesting the court to do so. The only plausible explanation is that a majority of the en banc panel was not pleased with the outcome that the panel was prepared to reach. And because of all of these types of shenanigans, the plaintiff correctly points out, nearly 16 years after Heller, the time is ripe for this court to establish what should have been clear the day that decision was released. Bans on firearms commonly possessed by law-abiding citizens are simply off the table. The application of that principle to this case is plain. Modern semi-automatic rifles such as the AR-15 traditionally have been widely accepted as lawful possessions, and today are owned in tens of millions by law-abiding Americans for self-defense and other lawful purposes. Such arms simply cannot be banned. And then the plaintiffs finally point out, and they do acknowledge that this is a big ask to have a certiorari review granted pending a ruling from the lower court. While granting certiorari before judgment is not standard operating procedure, the situation facing the court is atypical. A fundamental right is at stake. The proper outcome is clear, and the behavior of the lower courts indicates that this court's intervention likely is necessary for that fundamental right to be vindicated. This court should grant review and hold that Maryland's semi-automatic rifle ban is unconstitutional. So listen, this is a big, bold, brash move. Kudos to the Second Amendment Foundation for having the courage to push forward. What they outline in their pleadings and all of this gamesmanship, this delayed tactics, the shenanigans that have been going on in the Fourth Circuit, the Ninth Circuit, we see it through the state courts, and all of that is absolutely destroying the inalienable rights of lawful, responsible Americans nationwide. The case, once again, is Bianchi v. Brown. We will link up the petition down below so that you can read it for yourself. We'll also link up Supreme Court Rule 11 so you can see what the burden is that the plaintiffs will have to show. In addition, we'll link up down below for the Second Amendment Foundation, so if you guys want to show them some love, you will have the ability to do so. Now, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that information is also down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.